Yes. Where I was, the point which I was, making. Well, let me put it like this. When we try to undertake, when we try to take into account this entire project of the constitution making, constitution drafting, and constitution devising, we basically try to understand what should be the fundamental principle of our drafting of a constitution. Suppose whenever any kind of inquiry is conducted, whenever any society is formed, whenever any kind of a commission of inquiry is set up, then its terms and references are basically deliberated and identified, while keeping in view what exactly should be the motto of these kinds of formations of commissions, committees, and other important dimensions. Same is the case with that of the making of a constitution. First of all, it is pondered over by the collective wisdom of any kind of a constituent assembly, any kind of a legislative body, or any kind of a loya jirga, or any kind of a majlis, sansad, knesset, whatever may be the nomenclature. So basically, we agree on certain terms and references, whether the constitution is going to be republican, whether it is going to be democratic, whether it is going to be a secular, whether it is going to be a religious document. We try to understand, first of all, what kind of a nature of our polity would be. So basically, we try to define the terms and references. And these terms and references, my dear friends, comes from an idea of the basic structure of international law, the basic structure of international constitutional law, the basic structure from fundamental principles like constitutionalism, pluralism, diversity, multiculturalism, and cosmopolitanism. And these cumulatively create constitutional moments in the history of constitution making, or in the history or existential history of nations, international organizations, and other important and geopolitical entities. I'm not what you call saying something new, what I have already submitted. It is a new kind of a version of my unrecorded what you call submission. And this I have repeated because of the online students. So while taking into considerations these ideas of constitution making, a constitution is drafted. It is very, very important. Those students who have studied particularly from India, the idea of the basic structure of the Constitution of India, same kind of a reasoning must also be reflected in the area of international law. So there is a basic structure of international law, which I address as BASIL, BASIL, the basic structure of international law. So in one of my writings on artificial intelligence, I have developed this particular notion of BASIL, and entire I have devoted as many as more than three important pages. In those pages, it is in public domain. It has already been published. So I have developed this idea of BASIL, the basic structure of international law. And recently, one of my students from Bangladesh has also written a book on international law. So he requested me to write the foreword of that very book, of the nature of the contemporary international law. So I have also contributed around 1,000 words. What is the correct nature of the modern day international law, and what kind of a metamorphosis and even the peaceful one, cataclysmic one, have been taking place in the arena of international law. So that I have submitted. Definitely I will share that very forward, as well as this 3 pages from this particular research paper. So that will also strengthen and make my submissions further crystallized, whatever I am making before you. So this is the understanding. Another important observation which has also been, their international constitutional moments, my dear friends, might be quite useful with respect to paradigmatic, shifting developments within a particular international organization with constitutive instrument that acts like a, constitution. So there are, certain important regional arrangements like African Union Charter. So they have also, adopted some kind of a, constitutive act. Or right now, new important, specifically, economic oriented or economics driven organizations are also emerging. G77, G7, G8, all these kinds of, organizations are, there. ASEAN, NAFTA, BRICS, BIMSTEC, all these kinds of, organizations are, economics driven organizations, as we have also having, another important, what you call, Silk Route, what you call, belt. So that is being initiated. This is a, initiative that was, undertaken by government of, China. I think in 2016 or 17, I also, advocated that India should also be the part of this, road and belt initiative on the part of, because just to what you call, instead of sitting outside, we should be the part of this particular, though my argument has not been taken very kindly by the political, bosses or the political, understanding, but in some of the, researches, that argument has been what you call, critically cited in subsequent, what you call, books. So if government of India is today deciding that it should be the, part of this initiative, it means, and I have also provided a note of caution that will create the idea of, Indian sovereignty over CPEC, particularly on a portion that is what we call, passing through Indian territory. China Economic Corridor. So China-Pakistan Economic Corridor, this is the, abbreviation CPEC, and that is the, full form. So you can understand out of these, developments, how to exercise the, sovereign functions. And that should also be, reflected in the, constitution making, because it is the, Article 2 of the Constitution of India, my dear friends, that you can, what we call, reorganize, reclaim, or invite some of the important, territories from the, neighborhood. Because the Baluchistan, some of the important, portions of the, Pakistan, and my friends from Pakistan can correct me, particularly, the Gwadar port. Earlier, the Gwadar port was, managed by the, state of Oman. And there has been a, agreement between the, state of Oman and the state of, Pakistan. And ultimately, under this particular, arrangement, it was handed over to Pakistan. Same has been the history of what we call of, Hong Kong. On 1st of July 1997, that was also, handed over by the British government to the, Chinese government. And they have captured it like the, conquerors. They entered with, tanks as per the, Chinese model. And I don't know what would be the fate of, Taiwan. So, my dear friends, constitution making constitutes a very, very important, development. Because we have to reflect, we have to ruminate on certain important, what we call, developments, like issue. I have selected certain important, observations, and these observations are definitely you would also be, getting. Constitutions in South Asia are historically documents. It's a very, very important point. Do not write anything. I have written.
So, am I audible?
Yeah. Yes, Ms. Bakshi.
Sir, you just mentioned, you just took a reference of, so you just took a reference of Hong Kong. Hong Kong is a part of mainland China. and but still it has its autonomous powers. It has its own constitution. So how does this really work, that being a part of a country you are still autonomous and have its own constitution? I think by 2049 it will become a part of China.
Your concern is absolutely correct, Ms. Bakshi, but my concerns are different, because whatever the agreement that was brokered between UK and China in 1997, the spirit of that particular high contracting document is no more available in the daily life of Hong Kong people, because it has been promised not only in writing, but at the same time even the verbal promises were also advanced. The politicians from both the sides developed a consensus and understanding that there would be a freedom of what you call of free speech. There would be certain fundamental human freedoms, and those freedoms which have been enjoyed under the British rule in Hong Kong continue to be enjoyed under Chinese rule. Human rights, whatever the human rights were available during the British what we call period in Hong Kong, the same amount of rights, same thresholds of liberty, same amount of the free speech, same idea of constitutionalism would be enjoyed by the people of Hong Kong under the new rule, and that is Chinese rule. I do not see on daily basis. Even the recently a law has also been promulgated by the parliament of or the Politburo of China, that ultimately curtailed significantly many of the fundamental human freedoms of So on daily basis, that very agreement with which this transfer of power between the two nations took place is under proactive dilution. It is being diluted, and that too to the detrimental of the fundamental human freedoms. So after 10 years or after 5 years or after 15 years, you will be surprised. You would surprise that whatever we have deliberated today in the class is no more available to the people of Hong Kong. The idea of when China is claiming the idea of one nation, when China is making this particular highly preposterous argument, mainland China, one land China, I do not buy buy this kind of a nonsensical argument. It is very much detrimental to the idea of the basic structure of international law, as well as the basic structure of international constitutional law. So the fundamental freedoms are in jeopardy. They are going to be imperiled, and to very significantly have already been imperiled and compromised. So that is the situation. So people of Hong Kong, they have been experiencing very horrendous what we call political scenarios in their daily life. So, and nobody is there to question the sanctity of that very agreement. Even the government of even today, if the British government try to impugn the actions of the government of India, that you are not what we call holding the Independence of India Act of 1947, then government of India is not at all bound to react to those very observations. Simply what we call that would be construed as interference, British interference in internal affairs of India. For all practical reasons, we are independent. We are a sovereign nation state. Same is the situation with rest of South Asian jurisdictions, and same is applicable in case of China or Hong Kong. Yes, you were saying something, ma'am. Yes, Ms. Bakshi.
Sorry. Yes. Yeah. So I was just saying that the main agreement was the Sino-British declaration that happened. I don't remember when it happened. So in the part of that agreement, one of the main provisions of that agreement was that Hong Kong will remain autonomous for 50 years. And after 50 years, as soon as the 50 years will expire, it will become a part of China. So, but then China has been violating that very provision. So, would it be possible for Hong Kong to actually claim that, you know, they can get the autonomous? They should never become a part of China, because China has actually violated the very provision from which they are getting their autonomous status. So, would it be possible for Hong Kong to do
No,
that?
ma'am. No, I'm sorry to say it would not be possible, because we are having certain important, examples in the vicinity of China, like, Tibet, because the government of India could not, bargain on Tibet. It's a failure of, Indian foreign policy, particularly of the, previous regimes, particularly, Rajiv Gandhi regime and other what you call, previous, regimes. So we could not, bargain on Tibet. We could not what you call, sound the, or caution the community of nation states on the issue of Mongolia. We could not what you call say something on, Hong Kong. And we are also maintaining our geostrategic silence on Taiwan. And it is again a violation of the fundamental principles of, SARC understanding. Because as a SARC, what we call, nation states, we should also have our, perspective on international affairs. I'm not talking of the global south. I'm not talking of the 12. I'm not talking of what we call of some other regions, rather specifically to what extent we have been successful in the evolution of international law from the perspective of the South Asian nation states. We should be very careful, because we have given on plenty of occasions enough chances to the idea of bilateral relations. We have been deliberating bilateral issues, but what about the collective issues? What about the trilateral issues? What about the multilateral or idea of multilateralism in what we call having some kind of a understanding on international issues? Basically, if you witness today's international order, geostrategic order, or geopolitical order, or geoeconomic order, whatever may be the nomenclature, but you will find that entire world in near future, in the next 5 years, that is my what we call understanding, and that is my intellectual or juridical what we call prognosis, that I am of the view in the next 5 years, everything or entire what we call world order is going to be divided between China, international side. It is going coming down, and it is basically so far the foreign policy, American foreign policy, it is exclusively guided by the Jewish lobbies. I mean, the Israel is also playing a very, very important role in the shaping and making of US foreign policy. So this is going to be the world order, and but this is not a class of what we call of international relations, but it is one of the argument as per the course structure that is exclusively devoted to the treaty making and the foreign policy discourses. So to that particular aspect, I would further elaborate on this particular issue, but that is also reflected in our constitution, because whenever there is a question of entering into international treaties and international what we call treaty obligations, we try to what we call juxtapose, we try to engraft, we try to draft our international commitments within the what we call walls of our constitutions. And when we are setting them, when we are entrenching them, embedding them within this particular socket of constitutionalism, we are basically talking of fundamental principles of international law, international constitutional law. So that is the basic and the most fundamental idea that must also be reflected in the constitution making, whether it is the making of Maldivian constitution or the making of the latest constitution in South Asia, and that is the 2015 constitution of Nepal that was adopted on 20th of September. Any other observation? So therefore, my dear friends, historically embedded document. I was making this particular, reference. This should be attributed to the constitution, what you call, because historical significance cannot be underestimated. Likewise, when we talk of, constitution designing, design implies, my dear friends, a technocratic architectural paradigm that does not easily fit the many, what we call, or the massive realities of the, social information or the social institutions, especially not the messy process of constitution making. So what is important is that the technocratic architectural, design. If you have, how many of you have gone through the preamble to the United States of America? Do you have any idea of the preamble to the Constitution of Bangladesh? Yes, please. My friends from Bangladesh, can you tell me the preamble of the Constitution of Bangladesh? Yeah, please. Do not stand up. Because we have to understand what is the importance of a preamble in the life or in the existence of a constitution. That is equally important. Yes, my friends from India. But you are not audible to me. Speak a little bit loudly. You know how my voice is reverberating in this room. Yeah.
What is the sense of the whole the people of India who have accepted the constitution with the people have part of constitution. Basically, it's the idea of the India which has been defined. The idea was that we, the people of India, have resolved to justice, equality, fidelity.
It is not a question of what you call of cramming or memorization. When I am talking of architectural designing, because when we are talking of a basic structure of the Constitution of India or the basic structure of the basic law of Germany, first where this idea of basic structure evolved by Professor Joseph. So if you take into account this whole idea of basic structure, basically evolution of basic structure stems from the semantics of preamble. Or in other words, we may put it like this: the preamble to the charter, preamble to an agreement, preamble to a constitution, or preamble to a society, that basically constitutes the idea of the basic structure. Because it is the basic structure where from no deviation, no reservation, no exemption is possible. Under all circumstances, the government's institutions have been what we call, manned by personnel. They have to preside over the functions and the mandate of those constitutional, institutions within this particular idea of, preamble, which is known as the basic structure of the, international law as well. Because we are, migrating with certain constitutional ideas from constitution to international law, from constitutional law to international law, from international law to constitutional law, vice versa. So if tomorrow you are going to enter into an economic treaty under the auspices of the, International Trade Organization, on of the basis or in the area of because you need certain constitutional those in complements international law, and international law also complements constitutional law. So without the study of the constitutional law, and that too particularly in an intergovernmental organizational university like a South Asian university, there is no possibility of understanding international law without what we call invoking the fundamental features of the comparative constitutional law of our nations. So if at all we are interested, or we are really interested to understand international law from below, or from the South Asian perspective that remains in transition, that remains in evolution, we must try to understand the constitutional idea of constitution making. So this entire architecture of fundamental principles, that entire what we call technicalities which are required to be employed in the subsequent what we call provisions, are basically first of all pondered over and put into a document which is known as the preamble to the Constitution. So that is the importance of the preamble to the Constitution. Whole structure of a constitution, entire polity of a constitution, we generally define each and everything on the basis of this preamble. So preamble constitute a very important, and that is why, my dear friends, Supreme Court of India, as Mike rightly pointed out, has also handed down and cleared and settled this law, and observed that the preamble remains an integral part of the Constitution of India. In which decision? Yeah. Yes, you are right. So being I mean, you are not an Indian, even then it is important to know, and that is a very, very important understanding, because the decisions which are being currently delivered, or ever since the inauguration of the Constitution of India on 26th of January 1955, whatever the decisions are being delivered by the Honorable Supreme Court of India are being on many occasions, or have been emulated and incorporated as a precedent, as an enabling or guiding what we call precedents in some of the South Asian jurisdictions, and that too at the highest what we call judicial establishment level in these jurisdictions. So this is very, very important. Now, another important dimension, my dear friends, that comes to my mind is, and that is constitution or constitutions are made. They are not found. But you can debate this particular argument. They do not fall miraculously from the sky or grow naturally on the vine. They are human creations, products of conventions, products of what you call or outcome of the choices, the specific history of a particular people, and almost always a political struggle in which some in other what we call laws. Indeed, in this way, one might even want to argue that our constitution is more something we do. We again what we call reshape it all the time through our collective activity. And this is a statement which I have quoted before you, my dear friends, that has been given in a book that was written in 1987, and the name of the book was The Idea of a Constitution. I will share a soft copy of this book with all of you, and that has been what we call given by Hannah Pitkin. So she has written this particular book, The Idea of a Constitution, and therefore a permanent constitution, but there must be the work of quiet and body and great what we call deliberation. These are the words of the President Jefferson of the United States of America. For if a constitution is to be permanent, all parts of the state must wish that it should exist, and some what we call arrangements be maintained. And this has also been aired by Aristotle. I have taken only those very what we call affirmations from these authorities which are germane to our understanding. Otherwise, you can very well understand and you might have studied as a student of political science, what does Aristotle offer and other important what we call political thinkers, but it is equally important to understand that in contemporary traditions, constitutional arrangements usually originated with the bold acts of what we call purposive institutional what we call design. We also try to understand the constitutional design that involves migration of team and we should not use these are these long back in the senior were established as idea of constitutional development was in the Britishers in the country and years, I should say, these ideas have been deliberated during the what we call British regime and the post what we call British regime, or in the decolonized India or the decolonized or the post-colonialism South Asia or the SAARC region. But it does not mean, my dear friends, that the constitutions were not there prior to the earlier what we call times. Since the inception of humanity upon this beautiful planet, constitutions have always been there. Constitutions have been in the form of tribal rules, customary understandings, traditional doctrines, rituals. Everything has been what we call there. At this stage, I am not going into the nitty-gritty of legality, constitutionality, and validity of those what we call rituals, customs, traditions, usages, and other important forms of to regulate the human life. But this idea of norms, idea of understanding, idea of fundamental principles have always been there. And that is why it becomes very, very important to understand that how we are going to have a constitution. Therefore, my dear friends, whenever any exercise is undertaken so far the constitution making is concerned, then the endeavors, founders have tried to endeavor to regulate the future human conduct on the basis of speculative predictions. How institutions sometimes untried will actually function, and in the midst of what we call heated political conditions and heated political debates, that what we call rendered compromise inevitable. So you can very well understand if tomorrow we are going to have a constituent assembly for any of the jurisdictions in South Asia or beyond what we call South Asia, or I can give you an example of constituent assembly of Nepal. Anybody from Nepal? Yeah, you are here. Good. So in that way, constituent assembly, please correct me if I am, having some kind of a deviation. Constituent assembly of Nepal in South Asia has consumed immense time. Primarily after the decimation of the constitutional monarchy then constitutional monarchy in Nepal, an interim constitution in 2007 was adopted. There is a some minor differences are in there if you compare the 2007 constitution of Nepal with that of the modern day constitution of Nepal, particularly on foreign policy, international treaties, and other important facets. Yes. So we find some kind of a difference. I have both observations with me. What has been offered in the Constitution of the 2007 and what has been replaced and improved upon by the Constitution of 2015. So Constituent Assembly served many terms. On every occasion, his terms, what he called, extended to come out with the constitutional document of the constitution document before the, ratification of that very, or before the adoption of that constitution document. Various committees have also, served. They have been given some kind of a, brief. I can also share my own experience of Aligarh Muslim University, my dear friends. When Justice Chalaya Commission, Venkata Chalaya Commission was constituted in India by the, Vajpayee as the Prime Minister of India, Honorable A.B. Vajpayee as the Prime Minister, he constituted this commission. And one of the terms and references of this, to evaluate the working of the Constitution of India since 1947. So various committees and subcommittees were also, constituted. I was asked to act as a, rapporteur in a subcommittee that was, given to appreciate and evaluate and make recommendations on the rights of, minorities under the Department of Political Science in Aligarh Muslim University. So I have also, submitted my report as a rapporteur. And one of the, ultimate analytical argument which I offered in my capacity as a rapporteur from Faculty of Law of AMU, I made it clear that the implementation is the only glitch. The implementation is the only aberration. The implementation is the only gray area that must be what we call proactively attended and reselected. So far, Article 25, Article 26, Article 29, and Article 30 of the Constitution of India are this. Implementation part is the only bone of contention. And the proper what we call, constitution, a national commission constitution, a national commission for rights of, minorities or for minorities must also be embraced. So implementation is of vital importance. And how this entire trajectory is what we call, executed, I will definitely come to that aspect as well. But the point which I was, deriving home was relating to the Constituent Assembly of Nepal. My dear friends, on many occasions, it has been what we call, experienced by the Constituent Assembly of Nepal, that there were, consultations. Even the international consultations were also, taken care of. And some of the, consultations were offered from the South Asia as well, that you should not shift what you call your polity from the constitutional monarchy to what you call, secular what you call character of your polity. Please correct. But they have preferred a sovereign democratic republic instead of what we call of some kind of a theocratic state. Despite the fact 98% of the population, please again, I need rectification from your side, Ms. Karta. They are Hindus. 80% population is of Hindus.
Even Buddhists, there are Buddhists who follow Buddhism, and there are a lot of other minorities who follow Buddhism, but not as a.
You are sure?
Yes.
Because I am having some conflicting sources of information.
So in 2007 census data, there was
Well, there are scholars who claim, but as a student of, you are feeling cold, I am sweating. So my upper undergarment, that is my base, so that is drenched like that. Yeah. Well, I will go by your. No, it's all right if you are feeling cold. So, in the Constituent Assembly of Nepal, entire vast experience of monarchy was evaluated. Current situations of international law, international commitments and treaty obligations in the field of international human rights, fundamental human freedoms, particularly in the part of Nepal, were also evaluated. It was also thought that the experiences from the neighborhood must also be taken into account. And that is why they have strengthened their part third, their part fourth, which is exclusively devoted to fundamental rights and fundamental human freedoms, and the idea of what we call governance on the basis of state responsibility, state duties. That is exclusively devoted. They have invoked and strengthened further the idea of what we call the part fourth of the Constitution of India. It has been presented in the most robust form. Even the judicial experiences from India have also been taken care of. It is the uniqueness, and it has been the uniqueness of the Constituent Assembly, that we do not find certain important what we call commissions as a part of what we call constitutional scheme. But for the first time, it is the novelty of the Constitution of Nepal that majority of the national commissions were given constitutional places. We are having certain important commissions in the scheme of the Constitution of India, because the Constitution of India happens to be a constitution that immensely influenced the making of the Constitution of Nepal. That is my understanding. I may be wrong, you can correct me. Other constitutions were also consulted from the global north jurisdictions, and notably United States of America's constitutions happens to be in all the exercises of the constitution making at a national level. That has always been an inspiration, a guidance. So that was also consulted. But basically, the commissions like human rights commissions, another important what we call commissions, finance what we call commission, and many other commissions have become a part of the constitutional scheme, and that is not the case with that of other jurisdictions in South Asia. In the light or under the mandate of respective constitutions, except Nepal, various commissions have been established as statutory bodies. So that is the uniqueness. A wider spectrum of fundamental freedoms have been embraced by the Constituent Assembly of what we call Nepal. That is the most what we call refined document. Though recently it has also been amended. There have been certain important beakerings on the part of Madhesis. We would come to that also subsequently when we are going to deliberate on those very aspects in constitution, and how constitutionalism is going to serve as one of the most important remedial measures. So this is how, my dear friends, constituent assemblies have functioned. Therefore, again, if you take into account, my dear friends, how to, in a bullet form, in a capsule form, how we are going to visit the entire what we call exordium of to the constitutions. And this reminds me of that we should try to understand that the constitution making holds a great what we call promise. This should never be forgotten, because it is a very, very sacrosanct kind of study, sacrosanct kind of exercise. Constitution politics has the potential to establish hegemony of a new what we call democracy across a broad spectrum of social groups. What kind of a democracy? New kind of meanings are being attributed. Even today, what kind of a democracy we have been witnessing in South Asia, then we should ponder over. I do not wish to sound some kind of a political, or the politics should not be the part of what you call of my submissions. But this I leaves to your fine sense of judgment, my dear friends, how democracy is being interpreted and exercised in South Asia. Because everybody is having a different kind of a perception of democracy. I was seeing a drama from Pakistan. She alights from a flight that was landed from London, and she was there at the airport, Islamabad airport in Pakistan, and she comes out of the airport and immediately expects. And the opening sentence, now I feel democratic. Because in our land, we can expect, we can what you call litter some kind of a garbage anywhere as per our choice. That was her interpretation of democracy. Because this is a luxury which was not available in London. You can't litter. Similarly, I can also share another important anecdote. We basically, and you might have come across in your orientation program, my dear friends, the two important narratives: regional consciousness and South Asianness. These are the two important narratives, and these two important narratives must also be reflected in our academic research and intellectual engagements. We are here to cultivate a Western work culture. Western work culture backed by Asian values, South Asian values. This idea of the South Asianness must also be the essential part of our day-to-day engagements. Whether the academic engagements or the research engagements, whatever may be the nature of our engagements, but this idea of South Asianness, this idea of what we call, South Asians, what we call, understanding of regional, what we call, consciousness, should also be integral to those very engagements. A father slaps his son in Chicago because long back during his, prime youth days, he migrated from Pakistan to United States of America. One of our, former colleagues in South Asian University told me this, incident. Who was right now Professor Amanullah Malik, presently is the Dean of the Punjab University, Lahore. I think. Recently I came to know. He was earlier with us in the Faculty of Legal Studies. So that gentleman took his family. I mean, in the Navy, only wife was there. I think a kid of 4 years or 3 years of age was also with him. So he took his entire family to Chicago, where within the four walls of his home, he used to teach him each and everything: Islamic values, culture, entire Indian subcontinent values, history of Pakistan, history of India. Because history of Bangladesh is nothing without it. India, history of Pakistan is nothing without what you call India. For all what you call understandings, you have to understand the entire South Asia or Indian subcontinent history. So when that son turned out to be an 18-year-old guy, at that age, he got a slap from his father, and he immediately, on some mistake, he immediately went to a police station and lodged a complaint against his father that my father has slapped me. Then he was summoned by the police officers, and he was fined, and warning was also issued. All kinds of what you call measures which are required, which make a man a law-abiding citizen in the United States of America, were issued to him. And he also submitted an undertaking. Yes, this is a mistake, would not be repeated. But you know, the Indians and Pakistanis, they are of a different, what you call, clay. So subsequently, he pondered over a lot, and ultimately he created some kind of a, bonhome in the home, some kind of a, atmosphere. Let us have some kind of a, a visit in the days ahead, and we are going to visit Pakistan. And at least I should, expose you. I should, take you to your ancestral, what you call, properties, values, and to my, roots, my origins. You should also, visit. So he did not mention what exactly had happened in a police station and what kind of a treatment was, meted out to him. And they visited Pakistan. When he alighted at the airport, Islamabad airport, without anything, without thinking even for a while, the father slept again. Then he resorted to the same tactics. Son immediately, what he call, visited a nearby immigration official or police, official, that I have been slept. Then the police officer retorted back, who slept you? My father. Then the policeman again slept him. So these are the values. You might have committed some kind of a nonsense. How can you lodge a complaint against your father? So that is the, this is how you can understand the morality of law, the constitutional, values, fundamental human freedoms. Because there are certain important fundamental civil liberties and fundamental human freedoms which have not been addressed as fundamental human freedoms by the global north jurisdictions. But they are, freedoms in our part of the world. They are the part of our, civility. They are integral to our entire, what we call, civilizational journey. But they are not the part of, because we try to promote the idea of individualism with certain important, what we call, concerns. It is not the literal individualism sanctified by the Constitution or the constitutional, understanding of fundamental rights or the human rights. But if you see the other side of the, of this, globe, particularly the global north jurisdictions, you will find a literal understanding of the idea of individualism, where privacy, individualism, civil and political rights have been sanctified like anything in the constitutional scheme. But here in our part of the world, my dear friends, there are certain important limitations so far. The accessibility, affordability, and enjoyment of these civil and political rights are, concerned. We exercise them with certain important, what we call, accountabilities. Accountabilities may be governmental, accountabilities may be national, accountabilities may be spousal, accountability may be conjugal, and accountabilities may be parental, accountability may be, paterfamilial. So the nature and amount of, accountability is a multifold, what we call, dimension. It's a multi-dimensional. And the dynamics, we have to test the dynamics. We have to understand the dynamics of this entire, what we call, world of individualism or the civil and political rights within the idea of, collectivism, communitarianism, libertarianism, pluralism, cosmopolitanism. We cannot have a constitution which simply takes into account the idea of, individualism, idea of civil and political rights. that is not going to be sufficient for the global South societies. It is the element of collectivity. It is the element of cosmopolitanity that must also be reflected in our exercises of having a constitution which is delivering certain important promises of a high what we call nature. And my dear friends, this should not be forgotten. A constitution that does not have any kind of provision for fundamental rights, for fundamental duties. You will not find in Western constitutions the idea of the constitutional duties. Because the Western constitutions are rights-based constitutions. The global South, what we call constitutions, are both rights-based as well as the duty-based constitutions. And some of the constitutions, my dear friends, are exclusively duty-based constitutions. Every time we cannot claim that it is our duty to respect what we call our national emblems, our national symbols. No, that should be the part of our what we call understanding. This kind of argument is beyond the purview of religion. Everything cannot be clubbed together with that of the idea of religion. If I am not loyal to my land, if a Pakistani is not loyal to the land of Pakistan, or the Sri Lankan is not loyal to the land of Sri Lanka, he is not a true what we call Buddhist, a true Muslim, or a true Hindu. It is the part of that particular. It is one of the teachings of Hinduism and Islam and Christianity that one must be very loyal to his land. But because of political reinterpretations and the political misinterpretations, I should say, just to constitute a different kind of political experience, a different kind of political argument, people are given a different kind of a picture, a different kind of a shape of understanding. If I am being a citizen of India, if I am not loyal to my motherland, I cannot be loyal to you. I cannot be loyal to my parents. I cannot be loyal to my religion. That should be the understanding. But at the same time, we are here on a greater what we call project, and that is the project known as the South Asianness. So for a while, we should put aside our nationalities. Then we can understand this idea of what we call of comparativity. This entire picture of the comparative constitutional law of SAARC nations. Because if this has been a possibility, and it has become a possibility in entire Europe to have a European constitution, why not? It is not a possibility in our part of the world. Let us have. I am not talking of the political integration. I am not talking of what we call of some kind of a sovereignty, what we call integration. But at least we can have some kind of economic integration, psychological integration as an entity which is known as the SAARC. So that should be our fundamental understanding. Without diluting, without losing our respective sovereignties, we can be or could be an entity at regional level, where the idea of the global security, where the idea of the global economics, where the idea of what we call the global diplomacy, idea of the global international relations, idea of what we call space research, idea and concept of the marine research, in the field of global communications, in the area of international trade, we can have a collective approach, a South Asian approach. We can be the part of what we call of the South Asian research in these what we call, innumerable fields. We can have a collective what we call, space station, where entire what we call, community of nation states from our part of the world must be the stakeholders. If international research space station is installed and established in space, why not a South Asian, space research center? So we have to think beyond the box. That should be our, brief. Minor, political, gimmickries, political, bickerings, or some kind of a cultural, bitchings, that should not what we call, shape our entire, understanding while we are, studying comparative constitutional law or the South Asian perspectives in different what we call, courses, which are under what we call, teaching currently. That should be, motto. With this, amount of understanding, my dear friends, how to frame a constitution, a larger what we call, question that still remains to be debated. My dear friends, the chief risk of, of constitution making may be the risk that it will be abused by powerful political actors or social groups for their own ends. Because the constitution making is not only a very, very important process, but at the same time, it also what we call, a cost with very vital, dangers. Because whenever we are entering into this particular, exercise, we are also going to grapple with certain important developments. Developments in the area of, women rights, women rights movements, social movements, civil society institutions responses, elite class, the responses from the haves and from the have-nots. All kinds of, responses should be taken and placed as a record for deliberation by the Constituent Assembly. Because the dominant, regnant social groups, they are going to have some kind of a cascading impact upon constitution making. So the constitution making is a double-edged what we call, weapon. How you are going to reconcile, because the diversity and multiculturalism must also be reflected in the constitution making. How we are going to have some kind of an, equitable society. How equality in various aspects of the human existence going to be reflected and achieved under the constitution. The larger what we call, goals. What kind of a, interpretation should be there? Because the interpretation constitutes a very, very vital what we call, component of any of the, principles adumbrated, incorporated, reflected in the scheme of a preamble. Because on daily basis, my dear friends, we try to interpret. We generally don't notice when you say something, when a boy says something to his, girlfriend, and girlfriend is not happy, and most of the time they are not happy, then immediately the next sentence comes out of the mouth of a boy is, I didn't mean it. Actually, I wanted to say this. This is what it is, interpretation. On daily basis, we enter into the field of, interpretation. So to understand the idea of interpretation, some kind of a rocket science is not at all required. Interpretation is something which is always with us. Now when we try to formalize the idea of interpretation, we talk of, rules of interpretation. How we are going to, and that is why in each and every legislation, my dear friends, there is an interpretation clause. Sometimes it is also known as the definition clause, and that is the part of each and every kind of a legislation. And whatever has been the legislative intent that has been assigned as a meaning to that particular, word that has been used in the scheme of a particular, legislation, that must also be assigned. And beyond that, even it has also been, cautioned by the legislative establishment, even to judges, that they should not exceed it. The most famous, decision that has been handed down by Lord Justice, Wensleydale, in the Pearson, what he call, case, that the judicial mind is exclusively, allowed, or the judicial wisdom can only operate to an extent that serves the purpose of the, legislation. And the violence with the language or the modification with the language can only be extended up to that very extent that achieves the intention of the, legislation, not beyond that. If you try to understand the what exactly, and you might have studied in your BLV programs, the rules of interpretations, whether it is, grammatical rule of interpretation, literal rule of interpretation, golden rule of interpretation, harmonious construction of language, or the mischief rule of what you call of interpretation, or the historical rule of interpretation. But in today's circumstances, my dear friends, the international rule of interpretation, international law rule of interpretation must also be taken into consideration, because the rules of interpretation are all also the rules in evolution. In each and every what we call branch of the legal studies, you will find a different kind of an evolution of the rules of interpretation. Under international refugee law, we are having some other rules of interpretation, and in fourth semester, if you happen to be there, definitely I will let you know. So when we try to formulate, when we try to design, when we try to draft a constitution, this is the understanding that the political movements, the social movements, they are also having some kind of a impact. We can also put it maybe excessively majoritarian. Politicians and social groups may manufacture momentary majorities, either real or invented, to remake the state in their image. How to make a constitution? Because most of the things, my dear friends, whenever we undertake and whenever we try to emulate the constitution, what we call making exercises, we also confront with the idea of manufactured majority. Majoritism or majoritarianism is a very flawed argument. I am comfortable with the idea of rights of majority community. I am comfortable with the idea of the rights of the minority community. But as a student of comparative constitutional law, if you put this question to me, my dear friends, I am totally against the idea of minoritism or majoritarianism, because these are the dangerous territories. Because when we enter into majoritarianism narrative or minoritism narrative, we are in a state of conflagration, in a state of conflict. It's a dangerous what we call territory, and we should be very careful while treating those paths. Because we are here to talk of rights and duties together. Because it is a well-established fundamental principles, my dear friends. A constitution devoid of fundamental rights is not a constitution, and that was the controversy which was also faced by the, at the initial stages under the chairpersonship of George Washington, when he was, presiding over the Philadelphia Convention, convened for the constitution of, or making constitution for the United States of America. People like, Hamilton, they were totally against and they were not happy with the initial draft because it was lacking any provisions on fundamental rights. But subsequently, for a full-fledged ratification of that very, convention document, which is today known as the Philadelphia Convention, and that what you call document was construed as the, Constitution of United States of America when it got 10 amendments, and they were added as the, part of the, Philadelphia Convention document. So fundamental rights, fundamental human freedoms constitute the soul of a constitution. It is basically the kernel of all the constitutions. Any constitution that does not have any provision for fundamental human freedoms and fundamental human rights cannot claim itself to be a constitution. That is the modern understanding. And that is why, as late as in 1998, the government of United Kingdom came out with the legislation Human Rights Act 1998. And this particular piece of legislation has incorporated most of the provisions and taken those provisions from the European Charter on Human Rights of 1950 or 51. Prior to that, my dear friends, it was not possible for the British litigants, British advocates and attorneys to plead and claim any entitlement to any right under the European Charter of Human Rights. Because there was no what we call general incorporation of a regional treaty, and there was no possibility to have special incorporation of a regional treaty on human rights in Europe before the municipal legal systems of the United Kingdom. It was made possible only in the year 1998. But in the decolonized South Asia, it has become a reality with the inauguration of our respective constitutions. And subsequently, just to endorse our international commitments under the two covenants of 1966, Civil and UN Covenant on Civil and Political Rights and UN Covenant on social, economic and cultural rights, we have also passed, or the South Asian what we call national governments have also passed certain specific legislations on human rights. But these legislations turn out to be, in the subsequent years, only the paper tigers. These legislations do not have any kind of a biting teeth. And particularly in case of India, my dear friends, even the government of India did not bother about the recommendations of the Justice A.M. Ahmadi Committee recommendations, which ultimately what we call constituted how to strengthen the Protection of Human Rights Act of India of 1993. So these recommendations are gathering dust in the corridors of power. So nothing concrete has been done so far. But constitutions are very strong. Constitution of South Asia, my dear friends, in their current form. The constitution in South Asia, in their contemporary visage, they make a very, very strong case for the preservation, promotion, and protection of fundamental human rights. All citizens in this part of the world. And the making and whatever the rights have been incorporated in the Constitution of India has subsequently influenced the making of the constitutions in our part of the world, that is South Asia, and beyond it, even the rest of the constitutions, particularly the Constitution of Namibia, Constitution of Uganda, and Constitution of South Africa, Constitution of some of the jurisdictions in Latin American nation states. They have also got inspiration from the Constitution of India. So that this constitution has influenced. Even in 2003, at the Bonn conference, when the Bonn conference were deliberating the potential, or the future, constitution for the Islamic Republic of Afghanistan, they have also consulted our part of the, world, and particularly the Constitution of India. Right now, we are not having, and that was the, document prepared at Bonn that was adopted subsequently by the, government of Hamid Karzai in Afghanistan in 2004 as the Constitution of Islamic Republic of Afghanistan, Constitution 2004. Now, that constitution has been, set aside, and some of the provisions have been invoked by the Taliban regime from the Constitution of 1964, a monarchical constitution. So, in practical terms, there is no constitution in Afghanistan, but I have to deal with both the constitutions in Afghanistan, and whatever the provisional commands are there in public domain issued on the part of the Taliban regime, and they have completed 1 year in power yesterday, because last year in 2021 on 15th of August, Taliban captured power in Kabul. So they have also completed 1 year in power. So let us assess the constitutional developments, what exactly happened in Afghanistan in last 1 year. At the same time, my dear friends, scholars and public and policy makers studying democratic transitions need to shift the focus away from the moment at which the break with the old regime occurs towards the moment at which new constitution orders are constructed. But constitution making, my dear friends, promotes, and at the same time, the processes in countries like Tunisia, Egypt, and Libya, for example, are likely to be what we call determine in large measure what these new regimes will look like. So that, I mean, the international developments have also been taken care of. First of all, both the constitutional theory and constitutional law and politics have allowed constitution making processes to occur in a vacuum. Neither provides any real restraint on these processes. Second, the main risk of constitution making is that powerful individuals or political parties use either real or manufactured majorities to impose constitutions on the rest of their societies. And this is what I think that this is the argument which does not require any kind of a further explanation. All you understand, an urgent task in the constitution design and theory is therefore to construct models that will constrain this kind of a constitution making and to find ways to enforce those constraints. We must pay more attention both in scholarship and in international politics to the process by which new institutions are constructed. Observers, diplomats, and international organizations often pay great what we call attention to the democratic moment at which an existing regime falls. These actors pay far less attention to the aftermath which new institutions are generally constituted of. So these developments must also be taken into consideration, because if you take into account in majoritarian societies what kind of a references, what kind of laws are generally enacted. I can give you an example like hudud ordinances in Pakistan. What kind of legislations they came out with? Legislations like DSA, Digital Security Act in Bangladesh, like similar kind of what we call legislations or some specific legislations in India, which exclusively addresses the majoritarian what we call understandings, which have taken into account or didn't take into account the idea of inclusion and opportunity. I mean equal opportunity. So these kinds of what we call incorporations, these kinds of creativities in the name of constitution making should not be the part of that constitution what we call designing and processes, because ultimately the aftermath must be taken into consideration. What kind of repercussions, what kind of impact, implications in the subsequent stages general masses may face or confront with. We have recently witnessed what kind of legislations have been what we call, passed, even in India, and ultimately what has been the fate of those very legislations. So larger what we call, body or larger idea of, participation, larger what we call, idea or inclusive, participation, inclusive, ratification, inclusive what we call, debate should have been taken into consideration. Because we should not create a situation which ultimately what we call likely, or which is ultimately or likely to be boomerang. A situation which is going to victimize of the originator. So that kind of a situation should never be allowed to stay. And that is why the policy of referendum, the Switzerland idea or the Swiss idea of referendum on major issues must also be taken into consideration. And that should not be a statement of governance. That should not be what we call, a statement to weaken the present regime. At least if suppose tomorrow I am going to conduct a group discussion on constitution making, one piece of article I have given to 3 students or 5 students, and another piece of article I have provided to 5 students or 6 students, then what should be the what kind of a debate we are going to have? The girls are advocating the idea of gender. The students are from the minority community, they are basically emphasizing the rights of minorities. The tribal people are basically talking in terms of the equitable distribution of the natural resources in their region. And that has become a bone of contention in Jharkhand, in Telangana, in the Kalahandi region of Odisha, and the Delta region of Bangladesh, as well as what we call the Baluchistan of Pakistan, and some of the important mineral-rich regions of Afghanistan, which still remains virgin without any kind of exploitation. And this has been one of the most important motto of the international armed forces, to exploit those very regions for mining purposes, for beneath the what we call earth. There are certain important reservoirs which are going to sustain all kinds of developments in the global north jurisdictions. It is a fight for energy, it is a fight for natural resources. Take the example of Libya, take the example of Syria, take the example of Ukraine. Everywhere you will find, my dear friends, it is basically an economic exploitation. And that is why, my dear friends, it is important to understand international law and international law-oriented politics. Because if some powerful nation states are making a statement on a particular action that is a violation of international law, and the powerful nations themselves are violating the norms of international law on a daily basis, they are violating their own constitutions, they are violating their own foreign policy doctrines, and they are basically coming out with this kind of a euphemism or euphemistic statements. They are depicting a rosy picture of each and everything. But this reminds me of the Cicero, scratch the civilization, you will find dirt. So in their backyard, they are having all kinds of dirty what we call tactics, but they are also creating problems for other nations, for other what we call geopolitical entities. And that has become a bone of contention in the constitution making, because it has been the very vivid and livid experience of many of the constituent assemblies, where the non-state actors of their own country, and as well as the non-state actors and the governmental actors at international level, tried to influence the making of constitutions in respective what we call understanding. And for that, I would like to recommend a comedy. Whenever you find time in your leisure time, you should also see this movie. A movie, majority of you, I don't know whether you have watched this movie or not. That is a movie called Dictator. Right. So try to understand. Though I have mentioned some of the movies as a part of your course curriculum, but that is not a part of your examination. But just to give you and share some kind of a guidance how you are going to strengthen your understanding of the comparative constitutional law, you can watch those very movies. Even the interpretation, you will also understand what kind of a interpretation taken place in the helicopter in that very movie when they are flying over the river Hudson, right? So you can understand interpretation and other important aspects of the constitution making, because I don't want to overburden you with a lot of what you call serious stuff. Rather, I have taken initially a middle path, but day by day we are going to be serious in our engagements. So another important understanding, my dear friends, which I can give you, there are certain important constitutions, or in other words, contemplate what you call their amendments or amendments and changing of the constitutions that has also taken place. Particularly, I can give you certain important lists which should be taken into consideration whenever you try to study. Colombian Constitution of 1991, what kind of a intellectual postmortem has been conducted on this particular constitution. Venezuelan Constitution of 1999, then the Afghan Constitution of the 2004, the example which I have just shared. Ecuadorian Constitution of the 2008, because in 2011 it has also been what we call amended. And but among all the constitutions, I will let you know after Ecuadorian constitution, Bolivian Constitution of the 2009, and the Nepalese Constitution of the 2015. These constitutions are the classic examples of amendment, changes, replacement, repeal, and other important what we call metamorphosis of a constitutional character, which have been carried out in these constitutions. But Ecuadorian Constitution constitute a very, very important document. Ecuadorian Constitution, in the sense, my dear friends, it is the first constitution in all the constitutions across the world. Ecuadorian Constitution of 2008, which has for the first time recognized the rights of nature. Rights of nature. The rights of nature. The rights of ecosystems of nature. The rights of river. The rights of culvert. The rights of environment. I'm not talking of a right to a healthy environment that becomes your and my right. I'm talking of rights of what we call ecosystems. That is the beauty of this constitution. And now you can understand the idea of comparativity. Why and what is the importance to understand constitutional law on comparative footing? This is the idea of comparativism. We, my dear friends, as I have submitted in my earlier engagements with all of you, this is the importance, because we try to understand each other's systems, each other legal systems, moral systems, customary systems, political systems, legislative understandings on comparative footing. And this and intellectual understanding based on the cross-fertilization of ideas ultimately influence our constitution. What kind of a constitution? Right to asylum. We do not have, South Asian constitutions do not have provisions in their scheme of constitutions, right to asylum. But German constitution of Italy, these are the constitutions where you will find the right to asylum as a fundamental right. So again, it is basically made possible on the basis of our comparative study, or the comparative, what you call, understanding of constitutionalism or constitutionals. We are able to. And that is why I find the constitution of Nepal, the point with which I have started my submissions, constitution of Nepal has ultimately strengthened both the parts. Part third as well as part fourth. Rather, I see the idea of, ma'am, please correct me, idea of constitutional hybridization reflected in the making of the constitution of Nepal. Whether it is going to be the federalism, whether it is going to be the constitutionalism, or whether it is going to be the, the judicial independence. Or, in other words, allow me to invoke the idea of Professor Amartya Sen in his what he called, famous treatise, the idea of justice, where he is talking of transcendental institutionalism within inverted commas. The idea of justice that has been equated. Professor Amartya Sen comes out with this idea, transcendental institutionalism. It means a highest level of sacrosanct understanding to the functioning of the institutions was accorded by Amartya Sen. And this is how the idea of justice can be materialized, could be materialized. So this should be the part of our constitution making. Are you getting it? So that is how, if you are going to have this comprehensive cumulative understanding, how constitutions are generally promulgated, enacted, and what kind of requirements. This is something, my dear friends, that should be considered the pre-constitution making criteria, contours, and reflections. With this, we should try to understand and try to dabble in the area of constitution making, because all these countries, whether it is Bolivia, Colombia, Afghanistan, Ecuador, or Bolivia, Nepal, all these what we call countries, they have basically utilized constituent assemblies to replace their constitutional text, and use of a constituent assembly to replace the old constitution, and that was not mentioned in the old constitutions. I mean, the innovations with which they have come out with this kind of a understanding. And therefore, my dear friends, if you take into account the entire what we call international law praxis to international law processes must also be reflected in the constitution making, then, my dear friends, international law has traditionally held a state's form of government to be irrelevant, because historically speaking, international law was concerned with the relations between states rather than with the relationship between a state and its own citizens. But it does not mean we can dilute certain important international law, particularly the customary international law prerogatives, priorities, principles of a soft what we call nature, like international rule of law, like multiculturalism, like diversity, like pluralism, legal pluralism. Because some of the if you take into account, if I put a question to all of you, how to define the Constitution of Canada in a one single word, we find only one word, and it is the scholarship of Canadian origin that has come out with this kind of an expression. Multiculturalism is the identity of the Constitution of Canada. Constitution, France, diversity. They define the identity with this word. So identity, constitutional identity of an individual and constitutional identity of a constitution. Both should be understood. And that creates a constitutional culture where constitution becomes, or constitution making becomes possible. Otherwise, it is going to be a very difficult task. Now, at this stage, I would like to invite your questions, and thereafter I will proceed, further. Yes. Your question, ma'am? Hmm? So you haven't started thinking. Yes. Even don't ask questions, you can also express your own opinions. You are the equal stakeholders. Yeah, please.
So the thing about China and Hong Kong, so was that some of the people are saying that China is violating the agreement which they had with Britishers in 1997. But the case is that on the face of it, it may seem that the Chinese are violating the rules. But as per the agreements, the rules are not being violated. The agreement is being violated. But the case is that the system of Hong Kong is crafted like this that Chinese can manipulate the whole concept of democracy in Hong Kong after the 1997 agreement is flawed because certain number of legislators are elected by people and the majority of them are elected directly elected by the Chinese Foreign Bureau. So basically they control everything. And the flashpoint of that umbrella struggle was that the Hong Kong government enacted the extradition law and they were told by the Chinese, but it was not Chinese that as per the agreement protected on this.
No, actually, that has become a bone of contention.
Yes, it has.
And if you take into account, and this is the concern that was also raised by our online friend right now, she's available, Miss Bakshi, she has also, pointed out. So that is the, bone of contention between, Hong Kong and China. And remember one thing, my dear friend, as I have already submitted, and I should not give you a trite argument, but since you have raised this particular, issue, it is the military might. It is the might of the state of, China or Chinese state that is going to what we call, settle each and everything. No human rights, no advocacy for any kind of a, human rights, because of late what we have been, witnessing, and though our discussion is China specific, but at the same time there is a global trend. The global trend is that now the political bosses and the political personalities have been strengthened, are being strengthened, and the political personalities have made the constitution, respective constitution, subservient to their personality cult. It is not the supremacy of the constitution, but it has become the primacy of the individual. And that primacy of the individual in the constitutional scheme is a dangerous development. That is going to subdue the constitution. Because even there happens to be a political, activist, Mr. D.K. Barua, during Indira Gandhi regime in India, he crossed all the limits of, psychophancy. And he branded that India is Indra, Indra is India. And that was the most dangerous, And somebody has, repeated it recently in the context of, incumbent prime minister. He has also done the same thing to identify the incumbent prime minister. If we are saying that our nation comes first, so everybody becomes, secondary. It is the primacy of the state. Once upon a time, even the Russian state was, like this. Because it was one of the most important outcomes of the Bolshevik Revolution of 1917. That state and its structure, kind of, ecclesiastical status, a biblical status. Later half of the 20th century, a new development has taken place. This was recognized even in international law. Now the chapter of international law not confined states and international organizations alone also become the matter of international law. So in this entire what we call, development, I find, personally speaking, exclusively speaking, without imposing upon you, I find China is fit in the context of Hong Kong. Because if humanity is not there, if individuals are not there, if citizens are not there, then what would be the use of territory? So therefore, there has to be some kind of a reconciliation. We should not contemplate a state. A state should never be converted into a country like North Korea, and the political leadership should not behave as the chief executive officer. And citizens remain citizens. They should not be converted into employees. And this is what we have been witnessing in some of the nation states like North Korea. So can we talk of constitutionalism? Can we talk of human rights, judicial review? Even in our neighborhood, yesterday, that Nobel was convicted by courts in Myanmar. See, it was simply what you call a kangaroo kind of court. How people have been what you call, presiding over the institutions and trusted with the responsibility of the dispensation of justice. So another important right that is involved, and that is expected from each and every constitution when we are talking of fundamental rights or design of a constitution, my dear friends, that is a right to fair trial guarantee. The biggest human rights challenge, the biggest constitutionalism challenge. It is the right to fair trial guarantee. Can we ensure this? No, we cannot ensure. Whether it is Myanmar, whether it is South Asia, whether it is Europe, everywhere you will find. What kind of a court constitution has been there who convicted Saddam Hussein? Even the American and British scholars raised questions. It was not a fair trial. Even the Tokyo trial was also one-sided. And we cite very what we call, we celebrate the fundamental principles of a constitutional character evolved in the Tokyo trial, Nuremberg trial, Rwanda trial, Yugoslavia trial, where these judicial bodies have been constituted. And we can also question the recently concluded International War Crimes Tribunal that was constituted by the government of Bangladesh in the name of truth and reconciliation, in the name of transitional justice, whether in the true spirit of the transitional justice was meted out. What happened? What has been the achievement of the Truth and Reconciliation Commission in South Africa, in Sri Lanka, and what is the status of the transitional justice in Nepal, in Afghanistan? So these are some of the tricky questions and must also be reflected in the constitution making, because majority of the constitutions which have been constituted after a cataclysmic scenario or the violent what we call scenarios or conflicts, the post-conflict constitutions, they do not reflect generally on transitions. So that is the travesty of justice. So constitutional what we call justice, that should also be pondered over while designing a constitution. My dear friends, in my next engagement, I am going to provide you the role of preamble, the trajectory of what we call of participation, entire what we call, outline, and entire, stages, what exactly are the stages to make a constitution. And there are 10 fundamental principles with which we try to what we call enact a new constitution. I pondering over, and what has been the South Asian journey of constitution making. That is going to be my last what you call, submission in this week. This is something I would, attend next time. Meanwhile, please raise questions. My online friends, do you have any questions? Yes.
Thank you, sir, for
Yes.
giving us a chance to attend the class online. I don't have any special question. I would like to ask you about the. Could you please recommend us some sources or some topics to better understanding that lecture that you present us today? Thank you.
Yeah, thank you very much. You will get it. I got your point. I will share. No problem. Even if you want, bullet form or the capsule form, all kinds of information, but that would not be sufficient to write an answer in the examination, would also be provided. But you have to elaborate it. Yeah. Thank you.
Sure. Thank
Yes,
you.
ma'am. What is your idea? Don't land me in any kind of a controversy. Well, there are two. I have already exceeded your time. Yeah, we can discuss, but I will definitely come out because it's a very, very controversial one. And there are some, without any kind of historical reference, we cannot discuss it because how it actually started. What is the status of, of these two articles, Article 370, Article 9A, and other important provisions. And the similar, provisions are also there for other states in India. Kashmir was not the only state. There are many other states. Many special, provisions are also, there. So on the next occasion, yes, my dear online friends, there is a girl, I mean your classmates. So she's a very chirpy, very spunky girl, and she was, asking these questions, but very intelligent one. She wants a full-fledged deliberation on the abrogation of Article 370 and other articles in the context of Jammu and Kashmir, Indian part of the Jammu and Kashmir. And I have promised on the next occasion, we would definitely deliberate on these aspects. Yeah, thank you very much. I take your leave to leave.
So, Bhanbhai, are you there? Can you hear me? Can you hear me, Bhanbhai? Hello?